Hello everyone, my name is Francesca Table. Welcome to Gen AI Con. I am delighted to have with us here today Catarina De Alencar, who is going to be talking about generative AI and intellectual property rights and strategies to mitigate legal risks today. So a little bit of a background on Anna. So Anna is a legal counsel specializing in contracts, technology, and compliance. She is a legal researcher at the Artificial Intelligence Ethics and Law area of the Legal Grounds Institute. She is also an author of the book Artificial Intelligence, Ethics and Law, and a second book, Artificial Intelligence and Law, The Definite Guide. So I'll pass it over to you to give a more thorough introduction, and I'm really looking forward to your very important talk today.
Thank you very much, Francesca. So hello, everyone. I'm very happy to be here, and I would like to thank the invitation for this talk we will have today. So I was already introduced. Thank you very much for this nice introduction, Francesca. I would like to say that if you were wondering where my accent comes from, it comes from Brazil. So I'm a Brazilian lawyer, and I'm working and living in Paris now. I have experience in the AI law field. I have been working for law firms in digital law, providing legal opinions on how to utilize AI, especially generative AI, with reduced risks in many services and products that are now being developed. So the talk we will have today is about copyrights and AI, generative AI. And it's very important to say, as a first statement, that there are no certainties and that everything is under discussion in this topic. So we are in the gray area, so to speak. And the purpose of this talk today, the idea is to introduce a bit the scenario and to reflect about it with you all, because this is very open to debate, and we have to really build conclusion and thesis for protecting our content, protecting creators and the companies that work in this field too. So my purpose today is to bring some overview. It's not to be really exhaustive covering the topic, because it wouldn't be possible. It would take us days to do this. And even the courts, they are a bit lost on how to do so. I think the idea here is just to bring a brief introduction on this. So let's start. For those who do not know what is AI or generative AI, we have here a very simple introduction, very simple concept and definition, but that's important that we state this and clarify, because many people, they don't know what is generative AI. So generative AI is a subfield of artificial intelligence that handles the topic of creation with artificial intelligence, especially handles the team of how systems can create and produce content, such as text, video, audio, images, and many others. For example, we have nowadays the use of ChatGPT that's very popularized. We also have MidJourney and many other platforms that people use to generate content. So this is generative AI, the subfield that deals with this topic of creating content with systems. And what is the big issue about copyrights and generative AI nowadays? The greatest issue is how copyright law is dealing with the works that are created by the machines. For instance, are the works created by machines copyrightable? Who owns the rights to be author and to explore those contents from the economic and from the moral point of view? And this is not yet clear, and I would like to talk about this for a moment. So to start it with, is AI-generated content copyrightable? It means, can machines create, and is this content covered by copyright law? The courts and the offices of copyright copyright law are trying to deal with this topic. And here I bring to you in this slide a piece of a very interesting ebook that is called Zaya in the Dome. And this was generated by the author with AI. So the author in this case, she's Chris Castanova, and she tried to register her work produced with the help of generative AI in the Copyright Office in the US. This happened last year. And the US Copyright Office denied the registration of the work because, according to the office, only human created works can be copyrightable. And this is the case because, according to the most legal systems that we have in the world, originality and creativity are things related to the human spirit or to the human capacity to create. Since we need a human component in this scenario, totally generated AI works cannot be copyrightable. And this is what the US Copyright Office said in this decision. It said that the images, for instance, that were generated with AI assistance by Chris Castanova could not be registered and covered by copyright law. However, for the text that Chris Castanova produced, the office has granted protection because it was considered that for the text, there was originality and creativity and sufficient human authorship. So you may wonder, okay, but what happens for the images that she generated with AI? And in this case, she used MidJourney. Well, those images are not covered, not registered, and therefore they are in public domain. And the question is it fair or not? How we should treat this legally? We do not have an answer for the moment, but we have these cases and decisions coming up in the horizon that can give us some hints on what is about to come in the future. And it's important to notice that this expression, sufficient human authorship, is very broad and vague, even if it's it is subject to a lot of interpretation. There was another case in the US. It was issued by Toller. The name of the case is Toller versus Perlmutter. And the US District Court of Columbia reaffirmed this understanding because in this case, the author went to the court once he knew that the work could not be registered. And again, even the judiciary power, the court, reaffirmed the understanding of the US Copyright Law Office, saying that there is no ownership for works created entirely by an artificial intelligence tool. And in this case here, the image that is being shown in this slide and was produced by Creativity Machine, this is the name of the system, was not there was no work of human intervention. It was totally produced by AI. So the image you see here, since it has no human creativity or authorship, it was not covered and not registered at all. There was nothing that could be registered and protected by copyright law in this case. So these are two cases we have seen in the US. In Europe, we don't have recent decisions about this, about copyrights related to generative AI. But we can see that most jurisdictions in Europe also have the same spirit in the legislation, claiming for originality or requiring originality for the registration and protection of those works, and claiming too for the author's own intellectual creation. For instance, here in France, we have this understanding that we need human authorship to be entitled to copyright law. The same in Germany and many other jurisdictions in Europe. So in Europe, we will probably see the same path being followed by courts in the future. In the UK, however, we have a bit of a difference here, and it may be a bit more favorable to the creators of content because there is a law that is called Copyright Designs and Patent Acts, that give the rights to the registration of the work and to be covered by copyright law for the person who is arranging the creation of the work generated by systems. So if there is a proof that someone arranged this work, this person will be entitled to be the author and to explore the copyrights of this work. So it's a bit different, and there might be some different orientation for the UK court, since they have this law that states the person arranging for the creation of such work is considered the author. In China, we have also a decision, interesting one, in the Beijing Internet Court that determined that an image created by Stable Diffusion satisfied the requirements of intellectual achievement and originality, since the user provide intellectual input through the prompts and the text that this user provides, setting the parameters. So the work was considered original because the user had sufficient participation on it. And according to the court, the user and not the company that developed the algorithm held the copyright to the image produced, because the developer never wanted to produce it and never could have wanted to participate or to control the creation process. So in this case, it was considered that the creator was solely entitled to the copyright. So as you can see, and I will not go further on this, but it's very important to notice that the debate that is behind if AI-generated works are copyrightable or not is really related to the nature of creativity. And as you can see, most of the legal systems nowadays, they understand that creativity is a human phenomenon, and only humans are entitled to be creative, to be original. So only humans can be entitled to copyright law, and to be entitled to explore the works that they produce. The machines, they would not be entitled to this right for the moment. And this is something that for the future, it should be really considered a subject of reflection, philosophically speaking. If machines are capable to create with creativity or not, if this is really restricted to the human agency. And to go a bit further into this debate, we can divide this discussion in two levels in here. So the first level is to whether the copyright law protects the input or to whether it protects the output. And for the ones who doesn't know what is an input and what is an output, well, here we have a short definition. So an input, when we talk about generative AI, is something that the user gives as a command to the AI. So it's when you enter a text, for instance, on ChatGPT, saying that, for instance, you want ChatGPT to write you a novel about 3 amazing kids that enjoy many adventures in a sorcery school. So ChatGPT will produce content based on this input. This is the human-generated content. And on the other hand, we have the output. That is the result that the machine will give and will spit out to the user, let's say. So it is, in this case of this example I just gave, the story of 3 kids that live in a sorcery school, and many people would say that in this case, ChatGPT would give a result very close to the book Harry Potter, for instance, based on the command, based on the input. So the output is this result that is generated by the AI. So for the inputs, and it means the content that is generated by you as a user, we already saw that we need some originality, creativity, human authorship. so that this can be protected by copyright law and this can be copyrightable. So this is clear. According to the copyright law, this input, this content, that is also called prompt, must be original. And here we can interpret this as human, because this is what the legislation requires. Must be fixed in a tangible medium of expression, like for instance, it's a book or it's a work of art, it is inside of a computer memory, or it is in the paper. So it should be fixed in a tangible medium, and it should not be derived from someone else's work because it should be original. So even the inputs can be copyrightable. And there is an orientation by the US Copyright Office that says that the inputs of the user are copyrightable, and they can be even registered in the US at least. Because if they attend to the requirements of originality, yes, according to the copyright law, this is possible. So clear for the inputs. But what about the outputs? And that's where the legal problem, let's say, is. So the output is the content that is generated by the AI. And as we know, we have a problem, a discussion about this, and two possible understandings or positions in the legal field nowadays. So to start with, the outputs, they are generated by AI models, and the AI models, as you know, they need data to be trained. So generally, this data is taken from the internet, from works of people. So you have articles, books, videos, songs that are available on the internet, and AI is being generally based on this content that is available and that belongs to someone. It means that there is a copyright entitlement in this case to someone who is an author. Then most of those systems, they need to profit, let's say, from this content available on the internet to function, to train the AI algorithm. And this training is really a problem from the legal point of view for many scholars and many lawyers, because this content is taken from third-party content available on the internet that may be protected by copyrights that are not licensed. There is no authorization to use those works. And thus, we come to the issue. Is it fair for AI companies to use these works without compensating or crediting the original authors? So several newspapers, including the New York Times, for instance, have filed lawsuits against the big companies that generate AI output nowadays, like OpenAI and Microsoft, claiming that their AI technology undermines the newspaper industry. And also there is an interesting lawsuit that was issued by Getty Images, the platform of pictures and images, against Stability AI, claiming that they copied at least 12 million photos without permission or compensation for the authors. And also some deals are showing up in the horizon. For instance, OpenAI has signed a deal with Financial Times recently in order to deal with this question. And in this case, they celebrated what we can call like a license deal, through which OpenAI can use Financial Times content to train the algorithm, to train the AI model. And now we really have this issue. Is it really legal, or is it an infringement from the point of view of copyright law? How should this be interpreted, and what users and companies should expect for the future? So we have a first position in the legal field that will say that there is not a problem in here. There is no problem at all, because it's just the way that AI is learning, and it's not about really infringement. So these scholars, they say that what AI is doing now, generative AI, is the same thing that we humans do when we learn something. For instance, when a person, an individual wants to learn about something, they go to many books, they read a lot, and based on all this gathering of content, this person is capable of reproducing something. And some specialists, they claim that this is the same for AI now. AI is reading a lot of content available on the internet or in licensed platforms or in public domain and is learning from it. And according to those scholars and specialists, the purpose is not really copying the work of the author. The purpose is learning from it in order to produce a new product in society, something innovative and transformative. And according to this transformative purpose, it means it is something different from the work that was produced by the author. It's not derivative, it is transformative. According to the scholars, this training based on all the works available on the internet is covered by the fair use doctrine because it's transformative, it serves for a new purpose, it's not really copying to produce similar content. It is a training, a reading, a learning from a database in order to offer a new product for society. And also there's something to add that this reading of content that the algorithm is playing is not making copies to distribute the copies for the big public on the internet. It's not the case. It's really to learn from it and to transform something, to produce a new purpose. And this is an interesting argument because some similar analogous precedents were already analyzed. And for instance, we have Google Books versus Author's Guide that provide us with the same interpretation. Because in this case, Google Books versus Author's Guild, when Google Books started scanning all the content of the books, articles, and so on and so forth on the internet, and they were sued for this, the Supreme Court in the US understood that it was not an infringement of the works of the authors, because it was transformative in its purpose. It was to create a new product and to learn from this new use of the data. So many people are using this precedent in order to defend this view that the generated AI algorithms are learning from the content just like we humans do. And this is something that is covered under the fair use doctrine. And as you may know, the fair use doctrine exists in most of the jurisdictions nowadays. It can have nuances and differences, but we can imagine that if we have a big precedent in the US saying that the fair use doctrine is applicable to this situation, it will probably influence the other legal systems around the world. So I would like just to finish this first position, legal position, I would like just to read this paragraph by Professor Mark Lamley and Brian Casey in this article that is available in the Texas Law Review that is very instructive about this vision of the transformative purpose and fair use doctrine that is applicable to the training of the AI with copyrightable works. So they say, and it reminds us that fair use is about more than just transforming copyrighted works into new works. It's about preserving our ability to create, share, and build upon new ideas. In other words, it's about preserving the ability to learn, whether the entity doing the learning is a person or a robot. So it's about the process of learning, and also what is behind here is the enhancement of innovation in society and the development of technology and society itself, because the process happens all together. So it's very interesting to think about this. But there is a second legal position that says it's not true. They say that actually what is going on when generative AI uses the data available on the internet to train the algorithm, the algorithm is producing a collage of the original works or duplicated copies of these authors' works without compensation or authorization. And this would be an infringement according to the copyright law. Some authors, they even say that what AI is doing in this case is producing a verbatim regurgitation of the original work and copying expressive content mimicking the authors in this situation, and also producing plagiarism in some cases, since according to some of the studies that were developed so far, the output, it means the result that AI produces, is very similar to the original work. In some cases, it doesn't mean that it's the case for all the AI models, but for some of the AI models, it was already verified that this is the case. So these lawyers and scholars, they say that the companies that work with generative AI now, they should use only licensed works or works that are available in the public domain. And we have many lawsuits discussing this matter now. If there is a plagiarism in the output, if it is fair to use the works for the training of the data without compensation and authorization. For instance, the Getty Images lawsuit, for which we have no decision up to this moment, is very interesting in the sense because they said that also AI is producing content that will compete with Getty Images. For instance, in this case, they sued Stable Diffusion that is producing images that would be trained for the AI algorithm, but belong to Getty Images. And these images would also compete with the ones available in the platform of Getty Images because they are similar. So according to the authors of these lawsuits, AI-generated content is replacing the author and stealing audience away from them. So this is the unfair competition is also one of the biggest arguments. And something very interesting in the New York Times lawsuit is that they asked not only for compensation, even if they didn't put a number, as far as we know about the reports of this case, but they are also asking for an injunction to stop the alleged unlawful conduct. So in other words, they are asking the courts to suspend the service, to stop, to prohibit it. And it can be really something important in terms not only for the market, but only for society enhancement of innovation. And what are the perspectives we have for this now? How are the regulation bodies and governments trying to resolve the situation? Well, we have many considerations about this and no decision so far. We had some attempts to produce policies on the case, but as you can see, some they didn't succeed. For instance, in 2023, the British government tried to start an initiative to produce an AI copyright code of practice. And this initiative, unfortunately, was abandoned because nobody came to an agreement. There were many important companies participating in this group for the discussion of this code of practice, including OpenAI, Microsoft, Stable Diffusion, and many others. Also, participants from the civil society, lawyers and specialists, but nobody could agree on what is a fair decision and conclusion for all of this, and where are the infringements or where they are not. So this initiative was abandoned after some meetings and some producing of content. And in the US, we have a lot of activities being developed by the US Copyright Office. They issued the Notice of Inquiry on Copyright and Artificial Intelligence. They also provide a guide for registration of works containing material generated by AI. So they are trying to produce a lot of guidance and policies for this because for the moment we don't have any court decision So we are relying on policies, guidance, orientation from those bodies that are trying to pre-regulate or give some hints on the topic. In Europe, it's important to say that we had the approval of the European AI Act recently, and this AI Act, the legislation, it brings some possibility to regulate the matter of copyrights in AI-generated content. For instance, the AI Act brings obligation for providers of general purpose AI models. For instance, ChatGPT would be categorized under this name. And it says that the companies that provide for the system, they should observe and protect intellectual property rights. They should put in place a policy to comply with union law on copyrights and related rights. And they should make publicly available a sufficiently detailed summary about the content used for training of the general purpose AI model. So these are the obligations that companies under the European AI Act would have now. And especially for the third one, making publicly available the content used for training can be very valuable for this discussion, because for the moment, people do not have visibility. Even the governments, they don't know, the courts don't know how many algorithms are trained and what type of data they are using for this training. What we have seen in some of the lawsuits until this moment is that unlicensed content and content that's not available in public domain are being used. So it's really an obligation that can help bring some compliance on this matter, understanding what data it was used to produce the generated AI content and to train the algorithm. So a bit of useful insights to conclude this small talk, and to give some suggestions, especially to creators and entrepreneurs in this area, because it can be very difficult to deal with all these uncertainties. First of all, it's important to say that it's not a piece of legal advice, even if I've been working with this topic for quite some time now. This is not legal advice, but there are some small suggestions or orientations that we can draw from all of this. And the first one is that if you want to have your content protected by copyright law and you are using generated AI tools to produce it, you should really consider increasing the level of human interaction, human review on this work. Because as we have talked in here today, the courts consider that only sufficiently human-authored works are protected under copyright law. So if you have a work that is entirely AI-generated, probably you would not be covered and you will not be able to register it. It means that your work can be put in public domain and everyone can explore it and can use it. So increasing the level of human review in works generated by AI, so that they can be considered original and thus protected by the copyright law. These include, for instance, working and revising a lot the texts that are AI generated. For instance, if you insert an input, in the ChatGPT system and you receive something, you should work on it, not only for grammar and small corrections, but really interacting and involving yourself in the content so that it can be considered humanly altered. It is very important. Adding comments, critiques, new interpretations, this is what is going to make this work really original. And this review should not be limited to formal aspects. As I said, it should really be original, be adding and bringing some new value. And something that is also very important to have in mind is that the public should be informed about the use of AI in the AI-generated works, especially if you are selling those works. So I will give you an example here of a case that is real. I worked a bit on it, and yes, I can say that it's complex, but it illustrates this a lot. So imagine that you have a startup and your idea is to summarize books that are available on the internet. You are going to use ChatGPT to do this. And then after you use another platform to generate audiobooks. So your idea is to use ChatGPT to summarize a lot of books, and you will sell those books in the format of audiobooks of 10 minutes. So your marketing for your product would be, in this case, understand everything about the recent book of, let's say, Yuval Noah Harari in 10 minutes. And this person would be this consumer. They would go to your platform and download the content, pay a fee for this, and they would know everything about certain book that was summarized by AI and translated into audiobook in 10 minutes. Okay, this is a very interesting idea, but if your content is 100% generated by AI, it should be in public domain, because according to the recent decisions that we have seen in the courts and in the offices of copyright law, it needs to be really human authored. So this is the first thing. And a second thing is the information to the public, especially if it's a product that's being commercialized. So in this case, if you are selling the books summarized and transformed into audiobooks, you should really inform your consumer about this. Look, this content was generated by AI. There should be a disclaimer there, because according to many consumers law in several jurisdictions in the world, the consumer can be misled if he does not have proper information on the product. And second, many laws that are, or initiatives of laws that are regulating AI now in the countries, they claim for this transparency as well. So for instance, here in Europe, in the EU AI Act, we have the obligation for transparency for all the providers and the companies that commercialize products generated by AI. This should be clearly informed if you are using these tools, especially for commercialization. And also, it can be very interesting to ensure that you have, especially if you are a company generating content and utilizing these platforms, that you have policies and training in place to give some guidance to the people involved in the process of content generation and commercialization. This would be very important to avoid any legal problems and risks. So what are your insights about it? Should generative AI be regulated to protect copyrights? Should it be entitled to copyright entitlement? This is a very good issue, and I hope this talk has contributed to enlightening a bit the topic and bringing some useful insights that can be really illuminating the future. Thank you very much. See you.
Do you have time for one question?
Yes, sure.
Okay, perfect. So with regards to human authorship, so if you are a creative agency and maybe some of your team members are now using tools, maybe it's MidJourney, maybe it's Stable Diffusion, there are so many on the market. Would you encourage those creative agencies to track the whole process? Because, for example, there was an ad by Under Armour, and it was controversial because it was so good. And people thought that this whole ad was created with AI, when in fact, afterwards, they showed the part that was, they used AI, and then there was a lot of VFX and very highly skilled tools, which are also maybe not completely human authorship. It's you're using a digital tool. So do you think that that might be part of the solution, because it's so nuanced to say human authorship?
Yes, very good question, Francesca. Thank you for this. So first of all, we should remember that according to the US Copyright Office in the US and many other jurisdictions, the works that use digital tools, they are protected. The thing is, we need to know where are the parts that were not human generated. So we need to identify what was generated by the machine and what was generated by humans. And this is very important that the process is, as you said, monitored and it's historic, for instance, because this is how you prove that at least some parts of your work were protected or are protected under a particular law. If you don't have this track, it would be very difficult in case of a legal dispute, for instance, that you prove this. So what we give as orientation generally to people in this situation is that when you have a work that is assisted by AI in its creation, you identify what was really human authorship and what was not, what was totally generated by AI, so that you have this tracking on the process. And also that you somehow save and store the prompts that you inserted in the system. Even the prompts are copyrightable now. Let's say you have like an original idea of a prompt, something very crazy, you want to protect it, you can do. But yes, it should be stored, it should be saved, because if you have a legal issue in the future, the office is going to ask you, and this is exactly what is written in the guidance published by the US Copyright Office, that you should identify, okay, what was your part of human authorship in this and what was not? And for this, you need at least to have a memory of the prompt you inserted in the machine. If you don't have the prompt, how can you trace this back? It's very difficult. So what some other companies are doing now, like especially marketing agencies, big companies, they are producing some codes of conduct or guidance for the creators. And they are giving some orientations to people, like what should you do? What type of prompt should you create? Let's say one day you insert a prompt on the digital tool you are using, and it gives you a content that you have some suspicion it is a copyright infringement, because it's very similar to an author's work you saw the other day. So you have this kind of orientations to people so that they can understand what are the best practices when you use generative AI. So this is really something that I recommend. And this is a work that I've been developing in Brazil. And I also worked with this kind of guidance here in Europe. People, they need to know what they should and shouldn't do. For instance, some of the items in this guideline can be about discriminative content. Because when you are a creator and you insert a prompt inside of the ChatGPT, let's say, it can give you some content that is discriminatory, that is against the code of conduct and ethics of your company, for instance, that is not representative sufficiently. And you need to orient people, you need to guide people inside of your organization to show them, look, you have to revise this content. You have to see, okay, this is discriminating woman. This is not based on facts. These images can have some copyright issues because it's very similar to a work I saw on the internet the other day. So everything should be a matter of orientation. Since we don't have big lawsuits already resolved in the legal system, that's where we should work, in the preventive side, so that we orient people to have careful measures in this creation of content with generative AI.
Great. So if you are a brand and you're highly protective over that IP that you've created over a number of years, maybe you're Louis Vuitton, maybe you are Disney, I feel like there are kind of three different areas where that brand could be, there could be infringement in terms of the AI side of things. So the first is the data getting harvested and then training the model. The second being the user using the word, I want to create a piece of artwork inspired by Louis Vuitton or in the style of X. That seems to be the kind of the phrase that gets people out and covers themselves. And then the third part are actually users starting to upload content, taking a picture of a piece of artwork in a museum, all of the third-party apps that are going to be built on top of OpenAI. So even if maybe OpenAI, for example, as an example of a model, can argue that they didn't actually train the model. How are they going to distinguish between, what data they train the model with, and then, all of the third-party data, all of the data from users? They say that they don't train their models with all of this data, but I also hear that they do. So it's a bit confusing in terms of, version control. And I know with the EU AI Act, they can actually enforce for the model to be taken off the market. So there's an argument for having small models as opposed to large models that aren't too big to fail. So what are your kind of opinions there? I know I've given you quite a lot to think through.
Yes. So let's start with the brand infringement situation, because I picked up this topic from your speech, and I think this is very important. This is connected to the guidance we were speaking about before, because some creators and even some, let's say, employees in marketing agencies and so on and so forth, they don't know that they should never insert certain types of content into these platforms. For instance, let's say you use MidJourney to produce a lot of things, and this is nice. I'm not against the use of the technology. It's on the other way around. I'm very enthusiastic to it, and that's why I love to study this field and to work with this. But you should never, for instance, it's a very bad advice to insert brand material, or even to copy and paste texts, like let's say a document from your company that might contain a secret of your business, a business secret. So you should avoid data protection too. Like if you insert some personal data there, everything will be processed by the algorithm. Some platforms, they have an option. For instance, this I know because I've been providing legal guidance for the MidJourney situations involving MidJourney platform. Like MidJourney has an option. It's called stills, that if you click on it, if you have a paid license, the content that you upload in the platform are never shown to other users. And this is something very recommendable if you are a professional creator, or if you're a business, for instance, and you use this platform. And many other platforms, they have these options in their settings, in their configurations, where you can pick options that are more reliable for this kind of situation of hiding your content from other users. If you use the platform the way it is on the internet, let's say you put whatever content on ChatGPT and you try to produce a text, this will be processed by the algorithm, and it can be shown by the other user when they are using this, when they are inserting, for instance, a similar prompt to the one you produced. So some type of content from companies, from people, should never be inserted, because it can generate some legal situation, and you can never have full control over this content once you have uploaded it on an AI generated platform. So this is a situation. And the other situation is that, yes, the companies, they should comply to many legislation. The thing is, we don't have, at least in the US, in Brazil, for instance, in Latin America, we don't have a strong law for regulation of AI. We have some initiatives. And here in Europe, even if we do have the EU AI Act now, it's still starting. So even the companies, they have a time to adjust and to understand how the legislation would be applied and how it will be interpreted. So yes, it is a responsibility of, as you said, OpenAI, to review the algorithm periodically, to put some filters and do not allow copyright infringement. But this is still something that we don't know to what extent companies are really doing it, because the legislations are new. The topic of AI regulation is new, and it's for many of the jurisdictions now. But what we can imagine is that the companies, they are not very compliant, because many lawsuits are emerging now. And for instance, in the Financial Times, in the New York Times lawsuit, New York Times produced a lot of evidence that ChatGPT was producing content that was very, very similar to the one available in the website of New York Times. And it was like stealing the audience from them. So what we can see is that some evidences are showing us that there is not such a compliance for the moment. And the topic's new, so I can imagine that the companies, they are also trying to understand how to do this in practice. From the technical point of view, there are measures that they can take in order to, for instance, stop copyrightable works from being used, from being processed. For instance, there are filters that the algorithm can contain, not producing content when the algorithm understands that the user is asking for something illegal, for instance. And there is also ways to program an algorithm. For instance, some studies are saying that something called retrieval-based models would be a better way to program the algorithms to build the database and the training model, because they would be a better way, they would have a better way of tracing the database. So I could manage more easily what is licensed content, what is in public domain, what I need to get authorization to use. So this is, for instance, a technical solution that can be used. And we need some law enforcement. We need some decisions from the courts in order to see this movement of compliance happening. I think this is a tendency for the next years.
Absolutely, and I agree. Large language models with retrieval, augmented generation, or you have knowledge graphs, you can really track the data pipeline. So that's really useful. But then even if you train the AI model, it's not like you can have a takedown request. The only way you can stop that is, the whole model being sort of shelved. So it's difficult. In terms of your experience in the space enforcing compliance, do you think that governance tools are an important part of the solution? So we actually start to create more legal technology to solve this, because of course we've got terms of service. If you're an employee, you might have your employee handbook, but a lot of people don't read the terms of service, or they don't read the employee handbook, or it's just too lengthy. And I feel that technology is really good at picking up things. For example, with computer vision, you could probably pick up on a logo and some IP and stop that content even going into the model in the first place. What do you feel about the importance of legal technology to help to solve? There are going to be so many lawsuits that are going to start to be brought to the fore. So how are regulators going to deal with all of this? We need something to support them, I think.
Yes, agreed. And I think this is a very important part of the conversation, that legal is talking to technology. Let's say that those fields are really in a conversation, because this is the way we can understand better how to regulate it. The law is generally emerging after the facts, as we say in law school, for instance. So the law, when it's born, it's already old. And technology is always new and focused on the future. So that's why we need this conversation and this symbiotic alliance, really, of technologists with lawyers, with philosophers, so that we can understand better society and we can make it in a way so that law can enhance innovation and not block it. And the big risk that we face now is that all those regulations, they are going in a certain way that can really block innovation, and it's not for the benefit of society.
I agree. It's always
So I
seems to be
really
a
think,
tension between, technologists who want to go fast and break things and, work in the Wild West and look for countries without any regulation. So all startups will move to those countries. And then, the EU, which struggles with innovation, generally speaking.
yeah. And we have the what we call in law the Brussels effect. That is when you have a law in Europe, all the other countries are adopting it. So we are hoping that it will
I hope
happen.
so. Yeah, absolutely.
Yeah, but you see, like, for instance, the discussion in the US is a bit slow for AI regulation, and probably it will be a soft law, or it will not be a federal regulation. It would be regulated by the states. In Brazil and in Latin America, still a lot of debate. Some steps already taken in the Senate, but nothing yet totally approved. So, because this is also a debate that requires patience, requires people really talking, civil society participating, companies participating, so that we can understand the legal, the philosophical, and the technical aspects. And my biggest bet for this topic is education, is prevention. Because legally speaking, for now, we don't have precedents, as I said. We have some analogous case in the past, like, for instance, let's say in the US, we have the case of Google Books. But we don't even know if this precedent would be really considered analogous to what we have now. Because when Google Books scraped the internet to get the articles and books, it was not even the same type of algorithm that we have today. So we don't know if it's the same type of copying, so to speak. We don't think so. I don't think so, but let's leave it open to the debate. And that's why I really do this, place this bet on education, orientation, having governance measures in place, having trainings for the employees inside of the companies that are generating content with AI, trainings, instructions, documents, code of conduct, orientation, because this is what I have seen that is helping people to avoid legal risk and to avoid exposing IP contents, brands, business secrets, personal data inside of these platforms.
Absolutely. And I really like what you said before about, the almost a partnership between the tech world and the legal world. They need to work together. I think also, AI organizations and creatives need to work together, because if I were to look at the stock image industry, who originally might have sued Stability AI or those sorts of companies, and then within a year they do a U-turn and they do a partnership deal, so they're making some money out of it. They release a feature, or on top of that model, and the issue with that happening is now you can create so many images using these tools that the value of the original photos goes down significantly, just because of the sheer amount of content. But of course, those AI models require real content. Like, eventually, we can't keep on regurgitating the same content again and again and again. And I hope that, we're going to continue to create, so that we can keep the quality high. We don't just end up with this, copycat, where the AI models lose their quality over time, and that will be a very sad world that we live in.
Of course, and this is very interesting what to say, because some scholars, like the very strict ones, they are saying that big companies like OpenAI, Microsoft, they should only work with works in public domain. But if we do that, we know that the works in public domain, they are generally old. So the type of output we would have for generative AI would not be even useful for us.
Yeah,
The language would
biased. It would be,
yeah,
probably impolitically correct, all of those sorts of things.
exactly. So it's not useful. This is the problem with innovation and law. We really need to leave sometimes things a bit more open, and after we see how it goes, we regulate. Because if we do this before the right time, we block some process of important innovation in society.
Wonderful. Well, thank you so much. I know you're incredibly busy, and I'm going to point everyone to buy your books. Do you have any more books coming out?
No, but I have some article on this topic that is about to come out with some new legal research I've been developing. So yes, I will probably be sharing on my social network soon. Here in this slide, I have my LinkedIn for the ones who are watching and want to connect. And thank you very much, Francesca. It was very nice and instructive, very nice conversation. Thank you.
Thank you so much. I'm very curious about this topic, and sorry if I mix up all the legal terminology. I'm just enthusiastic about this space, so thank you very much for your time today.
No, you were almost like a lawyer. You were really bravo. No mix
legally
up. It was
blonde.
great.
Okay.
Thank you.
Thank you so much. Bye-bye.
Bye-bye.